Hello everyone, welcome to our channel. Today, we're diving into a critical topic for all healthcare professionals practicing in India, understanding your rights under the Clinical Establishments Act, 2010. Whether you're running a hospital, clinic, or diagnostic center, this law impacts you directly. Let's break it down in just 3 minutes. The Clinical Establishments Act, 2010, is a landmark legislation enacted to regulate and standardize healthcare services across India. It applies to all clinical establishments including hospitals, clinics, and diagnostic centers, whether public or private, and across all recognized systems of medicine. Under Section 2(c), a clinical establishment is defined as any facility offering diagnosis, treatment, or care for illness, injury, or pregnancy. First and foremost, Section 3 of the Act mandates that every clinical establishment must be registered with the appropriate authority. The registration process is governed by the Clinical Establishments, Central Government, Rules, 2012. Rule 3 requires you to submit an application in Form A, along with the prescribed fee and documents. Operating without registration? That's a punishable offense under Section 30, with fines up to Rs 5 lakh for the first violation and Rs 10 lakh for subsequent ones. Once registered, you must comply with the minimum standards of facilities and services prescribed under Section 12 of the Act. These standards are detailed in the Clinical Establishments, Standards for Facilities and Services Rules, 2012. Rule 4 mandates adequate infrastructure, equipment, and trained personnel. Non-compliance can attract penalties under Section 31, with fines up to Rs 5 lakh. Now let's talk about your rights as a healthcare professional. Under Section 14, you have the right to fair treatment by the District Registering Authority. If you're unhappy with their decision, Section 16 grants you the right to appeal to the State Council within 30 days. And don't forget, Section 13 ensures your right to maintain patient privacy and confidentiality through electronic medical records, EMRs, or electronic health records, EHRs. On the obligation side, Section 9 requires you to display your service charges prominently. Rule 8 of the Clinical Establishments, Central Government Rules, 2012, specifies that these charges must be easily accessible to patients. Additionally, Section 11 mandates that you provide emergency medical care without prior payment. And under Section 10, you must report notifiable diseases to the designated authorities. Here's what's new. The Clinical Establishments Amendment Act, 2021, introduced the National Council for Clinical Establishments to oversee implementation. Plus, the Clinical Establishments Central Government Amendment Rules, 2022, now require accreditation from a recognized body within 2 years of starting operations. Stay updated to avoid penalties. So there you have it. Your rights and obligations under the Clinical Establishments Act, 2010, in a nutshell. If you found this video helpful, don't forget to like, share, and subscribe for more legal insights.